Yes, Santhan, thank you. The Honorable President of the Commonwealth Lawyers Association, distinguished speakers, commentators, ladies and gentlemen, good evening. And to our guests from different time zones, good day. My name is Stephen Tiro. I'm the Vice President of the Commonwealth Lawyers Association Australasia region, and I am your host come moderator today. I'm very pleased to welcome you to this important webinar, Solidarity with Sri Lanka, Rule of Law Imperiled. The CLA has organized this webinar to share, discuss, and raise awareness on the current state of the rule of law in Sri Lanka. There is widespread concern that the government of Sri Lanka has taken and adopted steps that have serious ramifications to the administration of justice in Sri Lanka and that has threatened the rule of law. At the very outset, it is noteworthy that Sri Lanka has now distanced herself from the 2015 resolutions of the Human Rights Council of the United Nations to promote reconciliation, accountability, and human rights. Instead, the current government has announced that it intends to address the post-war legacy issues by a completely domestic process. Of concern, and in this regard, is a commission that was recently formed called the Presidential Commission of Inquiry into Political Victimization. It was formed sometime in January 2020. It was formed to review past investigations into criminal action on various crimes. The Commission has apparently recommended a discontinuance of criminal proceedings and the discharge of accused persons. These are quite unparalleled measures and gives fodder to the suspicion that there is a campaign to stop the investigations and prosecution of individuals for various crimes, and even to allow for summary exoneration. It is also of grave concern that individuals connected with the investigation of various crimes, such as witnesses, prosecutors, and judges, have now themselves become the subject matter of investigations. One such example is, I think, the recent arrest of the former head of the Criminal Investigations Department of Sri Lanka. These actions would undoubtedly have a chilling effect on law enforcement and cripple the administration of justice. There are also troubling policies that have been put in place to concentrate power in the hands of the executive branch of government. In this regard, the Constitution has been amended to increase powers of the president, including in the appointment of judges. The government is also becoming increasingly militarized by the appointment of various former military officers to key government positions. In general, military presence has been intensified by the increasing number of security checkpoints throughout the country. All of this has created a climate of fear, and the critics of government, opposition members, and members of civil society have been subjected to harassment and even arbitrary arrests. The United Nations Human Rights Council has recently, on the 23rd of March 2021, has expressed, and I quote, serious concerns at the trends emerging over the past year, which represent a clear warning sign of a deteriorating situation of human rights in Sri Lanka, unquote. Ladies and gentlemen, is the rule of law in Sri Lanka in a state of peril? This webinar will feature two speakers from Sri Lanka who will speak on the issue, and we'll have two commentators, one from Pakistan and one from India. They will draw parallels from their experiences from their own jurisdictions. I'm confident that their presentations will edify us and illuminate the true conditions on the state of the rule of law in Sri Lanka. Before I introduce the speaker, the next speaker, I just wish to put down some housekeeping rules. If there are any questions, you can put your questions in the chat group and we will take those questions out later. Please keep your mics muted. You can have your videos on, but mics muted, and we will take questions later at the end of the entire session after we've had the two speakers as well as the two commentators. With that brief introduction to the webinar, I would like now to introduce the President of the Commonwealth Lawyers Association, Mr. Brian Spears, who will give the opening address. Brian is the President of the CLA. He was elected in 2019. He has previously served as the President of the Law Society of Northern Ireland. He's also now the Treasurer of the Law Society of Northern Ireland. Brian practices as solicitor in Belfast, Northern Ireland, where he is managing partner of the firm of CMG Cunningham Dickey Solicitors. He works mostly in property development transactions, which include site acquisition, financing, planning, and development. Brian is a well-known expert in the area of mediation. He's indeed spoken on this platform a number of times on mediation. May I invite Mr. Brian Spears to address us and give us the opening speech.
Well, thank you very much, Stephen, and greetings to the panel from Belfast, and also greetings to everyone who has tuned in for what Stephen has correctly called a most important webinar on the position we find ourselves in when we look at Sri Lanka and consider whether or not the rule of law is in peril. It's my honor and pleasure to be with you today, although I feel somewhat overwhelmed by the magnitude of the task that you will be considering and the eminence of the speakers and commentators who Stephen has assembled. On behalf of the Commonwealth Lawyers Association, I thank Stephen, our Vice President for Australasia, for the magnificent work he will do today and has done recently in promoting not only the work of the CLA, but also the rule of law generally within our organization. The Commonwealth Lawyers Association is a rule of law centered organization of legal practitioners from across the Commonwealth, and I commend any listening who has an interest in the work that we do to check us out and engage and become members. Together, strength in numbers can make a difference, particularly on issues such as we are considering today. I have been once to Sri Lanka in November 2019 to a conference chaired by the then Justice Minister in Colombo, and it was a conference of the law ministers of the Commonwealth. And I was struck, of course, by how easy it is for politicians and senior legal officials to endorse principles espousing and agreeing with the rule of law, the separation of powers, and the independence of the judiciary and legal profession. However, it also strikes me that words in solemn declarations are insufficient and are inadequate unless matched by the real lived-in experience. The experts on the panel today will share their experience more specifically and more expertly than me on Sri Lanka. But I did want to take a moment or two to remind you of two areas where the Commonwealth Lawyers Association has participated in formulating principles that might assist further the consideration of the rule of law issues in Sri Lanka. The first of these is the Latimer House Principles, endorsed by Commonwealth heads of government in Abuja, Nigeria in 2003. They contain a number of relevant principles for setting the scene for today's consideration. Principle 2, for example, talks about the relations between Parliament and the judiciary being governed by respect for Parliament's responsibility for lawmaking and the judiciary's responsibility for the application of the law, and how each should operate in a constructive and complementary fashion. Principle 4 mentions how an independent, impartial and honest judiciary is integral to upholding the rule of law, engendering public confidence and dispensing justice and applying international human rights conventions and international law. Principle 6, very briefly, talks about the need for ethical governance in a parliament and how members of parliament and judicial officers should develop guidelines, particularly to address conflicts of interest. Principle 8 highlights the need for parliamentary examination of the proposed legislation of the executive. And Principle 9 mentions zero tolerance for corruption. Now, we know that in these international declarations, there is reference to how the legal profession should remain independent and should be allowed to represent their clients without fear of intimidation and harassment. So I simply ask, and I'm sure we will receive answers to these questions: how well is Sri Lanka and other Commonwealth members performing in meeting those standards that I have referred to? Does the government allow scrutiny of its decisions? Can the judiciary operate in an independent manner? And is there adequate or any parliamentary scrutiny? One must caution against legislating against a background of asserted emergency, but really with a view to increasing the potential for autocracy in the government. There is also the important area of freedom of expression, and there is available Commonwealth principles on freedom of expression and the role of media in good governance. These recognize the well-known principles from the Universal Declaration of Human Rights, everyone having a right of freedom of thought, conscience and religion, everyone having a right of freedom of opinion and expression and to hold opinions without interference, and everyone in Article 20 having a right for peaceful assembly and association. The Commonwealth principles on freedom of expression reference at Principle 1 how freedom of expression is a cornerstone of democracy and underpins good governance and respect for human rights. Principle 4 says, with regard to parliaments and the media, that Parliament should facilitate media coverage and respect the right of individuals and the media to comment on their actions and performance. And with regard to Principle 5 in the judiciary, it states that the rule of law, including the independence of the judiciary, is essential to uphold the right of freedom of expression and other human rights, and judges and lawyers should not be threatened or abused for upholding judicial independence or defending freedom of expression. And so, reflecting on these principles and the high standards that they set forth, I look forward to learning of the panel's insights, to the challenges which the panel will set out for the consideration of the CLA and others listening. I look forward to seeing how we might inform those in authority or the wider international community that Sri Lanka is on our radar and being observed, and to identify methods in which breaches of these principles and of fundamental rule of law issues might be enforced and those guilty of breaches held to account. I recognize the bravery and courage of those who speak out, whose voice is the voice of principle and of challenge. I support those who cannot speak out for fear of intimidation and hostility. I am humbled to have this opportunity to bring greetings, support, and the warmth of colleagues showing solidarity to our friends in Sri Lanka. But that is not enough. Words are not sufficient on their own. There must be action to match. And I repeat what a former Secretary General of the Commonwealth Secretariat said, that we must always guard against the gulf between rhetoric and reality. It is your reality in Sri Lanka to which the CLA offers support and solidarity today. I wish this webinar well. Thank you.
Thank you very much, Brian, particularly for reminding us about the universal principles contained in the Latimer House Principles of Guidelines. And that really should animate much of the discussion that we have today, and indeed, even as we take this forward after today in terms of what we should do. And I would fully, I think, endorse, and many would here endorse that whatever we speak about today, it should not be about just words, and then everybody falls back exhausted, because there's a real problem out there. And I think it takes people coming together from different nations, particularly within the Commonwealth, to stand up for the principles. Thank you again, Brian. Now with that, I wish to move to our panel this evening rather, here in Malaysia, and good day again to all of you. For the panel members and the commentators, can I ask that, okay, you have your videos on. You can be muted until you speak, but please have your videos on so we can see you, and particularly when you speak. And I have received the biodata of our panel members and commentators. And as you can imagine, they're all with high credits and very qualified. They will forgive me if I just do an abridgment of the introduction so that we can get into the meat of the matter. So the first speaker that we have today is Professor Dr. Neelam Deepika Udagama. She is currently the Chair Professor of Law at the University of Peradeniya, Sri Lanka. Until recently, she served as the Chairperson of the Human Rights Commission of Sri Lanka. She has also served in the Law Commission of Sri Lanka. She's an academic specializing in international human rights law. She characterizes herself as an academic activist devoted to social engineering through the law and education. Her human rights advocacy work has seen her actively being involved, including in United Nations human rights bodies. She was appointed by the UN Secretary General as a member and chair of the Board of Trustees of the UN Voluntary Fund for Sri Lanka, to the UN Subcommission on the Protection of Human Rights, and many others. I welcome Dr. Deepika.
Thank you very much. I'm going to introduce all the panelists, so am I to speak now?
Yes, you can speak, and I'll introduce them before they speak.
Okay, thank you so very much, and good evening to everybody. Honorable President and Vice President of the Commonwealth Lawyers Association, Australasia Division, and all the distinguished panelists. I must say I feel extremely privileged to be in your presence. And as a Sri Lankan and someone who cherishes democracy and freedom and rights of everybody, not only in Sri Lanka, but around the world, we are very encouraged by this initiative of the Commonwealth Lawyers Association. And I think all democracy-loving Sri Lankans will be in your debt for this, for drawing attention to this. Certainly, the rule of law situation in Sri Lanka is in peril. It's seen a vast deterioration since much of the improvements that took place in the past several years until about 2019. And that is what is of concern, because certainly we've seen improvements in Sri Lanka, but they're never steady. You see this sort of, back and forth. And currently we are seeing a great dip in the rule of law and opportunities of protecting human rights. But the current situation, including the enactment of the 20th Amendment to the Constitution last year, which has restored the full and omnipotent powers of this executive presidency, which is extremely damaging to the rule of law. and all these other developments, such as the recommendations of this Presidential Commission of Inquiry, etc., will be dealt in detail by Dr. Jampati Vikramaratne, my fellow panelist. I would like to put actually the current situation, because it's not something that just suddenly developed. I would like to put it in a bit of historical perspective. We need to recognize the historical developments in order to put things right, at least to begin to put things right back again, although the task seems to be Herculean. What I want to say is that when you look at the history of constitutional development in independent Sri Lanka, is that rather than promoting the rule of law in a very solid manner, the constitutional developments themselves contributed to the erosion of the rule of law. That is my argument. And so even when we are thinking of constitutional reforms, I think we need to talk about not purely just constitutional reforms, but instilling a very strong sense of constitutionalism in the country. That's absolutely of the essence. Now, why do I say that the constitutions contributed to this erosion of the rule of law? There's a certain paradox, I think a very stark paradox in constitutional developments in post-independent Sri Lanka. We've had three constitutions, as some of you who are familiar with Sri Lanka know. We had the Independence Constitution, which is known as the Salisbury Constitution, and then the two Republican constitutions of 1972 and 1978. Now, what you see when you, as students of constitutional law, is when you look at the three constitutions in quick succession, because the 78 constitution came just 6 years after the first Republican constitution. What you see, interestingly, are provisions that better guarantee human rights in the constitution over the years and over the three constitutions. However, running parallel to that are provisions which have eroded checks and balances and separation of powers, and hence the rule of law. So you see this stark contradiction. In the Independence Constitution, there was no Bill of Rights. There was only but a very strong provision about protecting communities from discrimination. And then the 72 Constitution saw a Bill of Rights, but no constitutional remedy for violations. And then the 78 Constitution saw a Bill of Rights, of course, with limited rights, but still, I mean, there were very important rights guaranteed by that Bill of Rights, which was accompanied by a constitutional remedy for violations. But then on the other hand, you see this progression of constitutional development being accompanied, as I said, by a whole array of provisions which undermined democratic institutions. And then, of course, it culminated eventually in the 1978 Constitution, introducing this all-powerful executive presidency, which was really, I would call it, without exaggeration, a death blow to checks and balances and the rule of law. So in the Republican Constitution, I would say that many commentators, it's not only myself, but I think many commentators are of the view that the Constitution that best guaranteed checks and balances, interestingly, was the Constitution without the Bill of Rights, the Independence Constitution, the Salisbury Constitution. But the first Republican Constitution, in the guise of promoting national pride and so on and so forth, what it did was it entrenched sovereignty of parliament. I mean, there's nothing wrong with that. But then what happened was the guarantees that accompany that form of government were not there. So you had a very weakened Judicial Services Commission, which was highly politicized, a very weakened Public Service Commission, which saw the public service being politicized, and so on, which did not permit the required checks and balances in government. So you saw every sphere of life being politicized, and we saw an erosion of the rule of law. And violence was also very much part of that era, beginning in 1971. Then you see in 1978, the second Republican Constitution, which introduced the executive presidency, which then, of course, concentrated all powers in the executive presidency, all judicial appointments to the higher judiciary, to the attorney general, all important positions were appointed by the president almost unilaterally. And then, so you see a much a further deterioration of the checks and balances and the rule of law. So it's a strange, journey in a sense, with all these contradictions. Now, this period also saw escalation of violence in the country. There have been several cycles of violence in the country. As I said, beginning in 1971, we saw a major insurrection in the South, a youth uprising, and a second insurrection in the South in 1987, 88, and it tapered off in 1989. This was against the Indo-Sri Lanka Accord that was signed between Sri Lanka and India, ostensibly to address the ethnic issue in Sri Lanka. Then you had the 1983 extremely serious, very violent ethnic riots targeting the Tamil community, and the same year saw the beginning of a 3-decade-long civil war in the north and east. And when that war ended in 2009, many of us thought we had seen the end of physical violence in the country. Of course, it wasn't a positive peace, as Galtung would say. It was a negative peace because the tensions were very much there, but the guns were silenced. But then again, around 2014, we saw sporadic attacks against the Muslim community, and especially the burning of commercial establishments of the Muslim community and so on. And then in 2019, we saw the devastating Easter Sunday attack against very peaceful Catholics who were in their churches observing prayers, and the retaliatory measures against the Muslim community, which again saw these cycles of violence. So if you really look at that Republican era, which should have been a very reinforcing period, we've seen these constitutional developments which have eroded the rule of law, and also which has seen this rise in violence, so that I think almost every community would say it has grievances, that they feel aggrieved, because all these cycles of violence were accompanied by very bad human rights situations, very strong, very devastating human rights violations of enforced disappearances, of torture, of long-term imprisonment, and so on, and extrajudicial executions. And of course, the statistics vary, but these run into the thousands. Now, superimposed on this very problematic constitutional framework was the specter of 40 years of governance under emergency rule. In order to deal with these cycles of violence, successive governments ruled under emergency. So the law of the exception really became the norm. And that, I want to say, has left a lasting sort of legacy, in the sense it has impacted not only on the political life of the country, but everyday life of the average citizen. There is a very strong, I think the current political culture is very animated by this national security paradigm. And now it has come to the fore in a very strong manner because of government policies and the government orientation itself, but even otherwise, even during the previous government, what we call the good governance government, we did see this national security orientation raising its head from time to time. And then there was the enactment of the Prevention of Terrorism Act in 1979, which had very devastating consequences for human rights protection in the country. In fact, some of us see the irony of it, and we call it the Promotion of Terrorism Act, because its provisions are so harsh. When you brutalize a society, when you brutalize a community, you pave the way for further radicalization and violence. So, you have this legal framework which, rather than protecting rights, including the constitutional, I would argue, really, goes against the protection of the rule of law, the upholding of the rule of law, and so on. And one dark thread that runs through this entire period is impunity. given all these cycles of violence and human rights violations, what you see is that impunity has become a way of life. I would argue that it is very much part of our political culture and our legal culture. There's an expectation that certain people are immune, they just cannot be. There cannot be, indictments or cases being brought against certain personalities or certain groups. Even I would argue that, during the previous government, which saw a lot of positive reforms on human rights and democratization, which also wanted to lay the foundation for reconciliation and so on, still, I would argue that impunity continued because none of these, what we call emblematic human rights cases, saw any conclusion, and they're still pending before courts. And as Jayampati will explain, I'm sure, now this Presidential Commission of Inquiry has recommended that those who have been indicted in those very serious cases now be freed. That they let go of these cases. So which furthers this legacy of impunity. We have very few cases relating to these cycles of violence, excuse me, which saw convictions. You can count them on the fingers of your, two hands. And also you saw about a year ago, one of the accused, one of the convicts in one of the most infamous of cases, Mirusivil case, where the man he was an army officer. He was convicted of killing 5 civilians, including a 5-year-old child. And a 3-judge bench found him guilty. The Supreme Court unanimously affirmed that conviction, but then a presidential pardon was made and the man was released. So this impunity continues. And so now we've got to ask ourselves, where from here? Where do you go from here? And you see these latest efforts at imperiling the rule of law, and particularly this constitutional amendment, the 20th Amendment, which I'm sure Jayampati will speak about in detail. What I would say is that, of course, we need constitutional reform, but democratic constitutional reform which entrenches constitutionalism. And what we need to ensure is that institutions are strengthened, because what happened over the years is that institutions, including the judiciary, have been, weakened. The Attorney General, the police, the law enforcement agencies, all the agencies involved in administration of justice, you really cannot say that they've been strengthened over the years. I think the norm really is about politicization. There have been periods where the judiciary has delivered magnificently, but then it's erratic because it's never a constant, depending on this, the sort of the government of the day, the constitutional provisions, and so on. So we need to entrench systems and not, I think in South Asia, this is a very common phenomenon of, politics and governance focusing on personalities and political parties. That has to go. We need to focus on, entrenching very strong systems. And then I also want to say a few words about my tenure as chair of the Human Rights Commission. We were appointed, the commissioners were appointed under the then 19th Amendment, which was clamored for by millions of people in the country because they saw the need to depoliticize these important institutions. So I don't think we should talk only about the judiciary. Even bodies such as Human Rights Commission, the non-judicial bodies, Election Commission, the Police Commission, Public Service Commission, all these commissions are so vital to democratic governance. I would say that the fact that the Constitutional Council was there under the 19th Amendment to recommend appointments to these bodies really made a difference. About my appointment, I cannot comment on that, but what I would say is that I got excellent commissioners who are committed to human rights, who represented all the communities, the diversity of Sri Lanka. And I think that added to our strength and our work. And today you have a Human Rights Commission, which is directly appointed by the president under the 20th Amendment. There isn't a member representing the Muslim community, for example. So this is extremely problematic. Then to speak about the Presidential Commission that recommended that some of these cases be dismissed, that particular commissioner has been made the chair of the Office on Missing Persons. So, these are very serious issues. So I need to point to how these legal reform, so-called legal reform, impact on lives of people in a very negative way at a practical de facto level. And finally, where civil society is concerned, I think we really need to reclaim our space. It's really now closed to a great extent. Many are very fearful of speaking up. It opened up dramatically during the previous several years. Now, the space has closed. And I think we need to show our mettle by being very holistic in our approach to this dealing with human rights violations and undermining of the rule of law by taking on the grievances of all communities. As the High Commissioner for Human Rights, Michelle Bachelet, said, let this resolution be the beginning of, treating of all members of communities enjoying human rights on an equal footing. So there's much work to be done. And I want to once again thank the Commonwealth Lawyers Association, the Australasia division, for this initiative and giving me this opportunity. Thank you very much.
Thank you very much, Professor Deepika. That was a very interesting historical conspectus of where Sri Lanka is today. And I won't say too much, but it just struck me that I think over the years, and I think this is a feature that we see in other jurisdictions as well, when there is prolonged emergency law, then there is an addiction to power that is very difficult to give up post-emergency. So it rears its head post-emergency, like as if it is an emergency, and that actually leads to a concentration of executive power and the executive not willing to give up power. And all of that, I think, harks back to the fact that you've had a history, as you say, for a number of years of living under emergency laws. Thank you again very much. May I move now to our second speaker from Sri Lanka, and he's Dr. Jayampati Vikramaratne, who joined the Sri Lankan Bar in 1977 and was appointed as President's Counsel in 2001. He was awarded a PhD degree by the University of Peradeniya for his thesis on fundamental rights in Sri Lanka. Dr. Vikramaratne was a member of Parliament from September 2015 to January 2020. He has served as a Senior Advisor, Constitutional Affairs to the President, Senior Advisor, Ministry of Constitutional Affairs, and Consultant, Ministry of Justice and Constitutional Affairs. He's a Director of the Institute for Constitutional Studies, an organization working on constitutionalism, devolution, power sharing, and human rights in Sri Lanka. Dr. Jayampati.
Thank you. Thank you, Stephen. May I first thank the Commonwealth Lawyers Association for this opportunity and also for organizing this event on the rule of law in Sri Lanka. The chair and the vice president and the other members of the Commonwealth Lawyers Association in particular. And the fellow panelists and also participants, thank you very much for joining us. I have a PowerPoint presentation. I hope it works. Does it?
Yes, we can see it, Dr. Jayampati.
Right, thank you. So I speak on constitutional changes which have impacted both positively and negatively on the rule of law in Sri Lanka. So some of these issues were touched upon by Professor Udagama. So as Deepika said, we had a parliamentary form of government up to 1978, and in 1978 a presidential form of government was introduced. The president was very powerful at that under the constitution. He may dissolve parliament at any time after 1 year, and even within that 1 year, if the previous parliament had run the full course, he could technically he could dissolve parliament after the first sitting of parliament, could have done that. and the president appointed the prime minister, the ministers and deputy ministers, and could remove them at will. And he had near total immunity from suit. He could not be taken to the Supreme Court even for a fundamental rights violation. The president would appoint judges of superior courts, the attorney general, the ombudsman, the inspector general of police, the members of the Public Service Commission, the members of the Judicial Service Commission, and other commissions which are very important for the rule of law. So there are no constraint at all. He could appoint anybody as a judge or a member of these commissions. Now, the powers of the president were restricted by the 17th Amendment in 2001, and a constitutional council was set up, which consisted of 3 members of parliament, the prime minister, speaker, and the leader of the opposition, and 7 from outside parliament. 1 was appointed by the speaker, 5 were nominated jointly. Now that is important, nominated jointly by the prime minister and the leader of the opposition. And 3 of them had to be from the numerically smaller communities. And 1 more member was nominated by the smaller parties in parliament, meaning the parties to which the prime minister and the leader of the opposition do not belong. So I would argue that the Constitutional Council process provided for an opportunity for a potential national consensus on appointments, which are so important for the rule of law. The Constitutional Council's approval was needed for the appointment of Supreme Court judges of the Supreme Court and the Court of Appeal. Attorney General, the Inspector General of Police, the Secretary General of Parliament, the Ombudsman, they all had to be appointed subject to the approval of the Constitutional Council. And the members of the independent commissions were appointed by the president, but on the recommendation of the Constitutional Council. So unless the Constitutional Council recommended, no person could have been appointed to any of the independent commissions. But then came the 18th Amendment. Before that, may I say that under the 17th Amendment, the first Constitutional Council functioned fairly well. But then the second Constitutional Council was never appointed under some pretext. And when the non-appointment was challenged in the Supreme Court said, sorry, we cannot hear you. We cannot take up this issue because the president has near total immunity. His official actions are immune from the fundamental rights jurisdiction of the Supreme Court, and therefore the Supreme Court could not intervene. And that was very important. Then by the 18th Amendment of 2010, brought by President Mahinda Rajapaksa after the defeat of the separatist LTTE, he still did not have a 2/3 majority, but he managed to entice number of MPs from the opposition to cross over, and they were of course given ministerial berths and other benefits, and then 2/3 majority was achieved. The Constitutional Council was replaced by a parliamentary body called the Parliamentary Council, the Prime Minister, the Leader of the Opposition, and 2 members of the Parliament and the Speaker. That would only make observations on top appointments. They had no veto power. They couldn't recommend. They had only to make observations on these appointments that I talked about under the 17th Amendment. And the original 1978 Constitution had, at least it was strong enough, strong presidency, but there was one safeguard at least, that there was a 2-term limit for the president. Now, even that was taken away. That 2-term limit was abolished. And I would argue that with the 18th Amendment, the Sri Lankan presidency became one of the strongest, if not the strongest, in the democratic world. But we were able to change that in 2015. After the change of government in 2015, the 19th Amendment was passed at a time when the new government had only 44 members out of 225. But still, soon after the victory at the presidential election, we were able to pass this 19th Amendment. the president's powers were greatly reduced. The term of the president and parliament were reduced to 5 years, and the president could not dissolve parliament for 4.5 years, unless parliament requested by 2/3 majority. The cabinet would be approved on the advice of the prime minister, and the president's power to remove the prime minister was deleted, taken away, and now the prime minister could be removed only by parliament, by either passing a vote of no confidence against the government, or defeating the budget on the floor of the House, or rejecting the statement of government policy. So parliament was strengthened at the expense of the president, of course. And very importantly, the president's official actions were subject to judicial review by the Supreme Court under the fundamental rights jurisdiction. And that, I thought, was a very that was a very important achievement by the 19th Amendment. The Constitutional Council was restored, but the opposition, without whose support we could not have passed the 19th Amendment, insisted that instead of 7 people from outside and only 3 MPs, that the ratio should change from 3 to 7 to 7 to 3. And so in the new Constitutional Council, 7 members, 7 from Parliament, and there are only 3 from outside. But still, it worked well. The appointments to the Supreme Court and the Court of Appeal had to be approved by the Constitutional Council. And there are several nominees of the president were rejected, much to his disappointment. Several nominees of the president were rejected to the superior courts. So there was this sense of independence. The Commissioner on Bribery and Corruption was given constitutional status. And there were new commissions appointed, like the National Procurement Commission, the National Audit Commission. And all these commissions, the Public Service Commission, the Police Commission, the Human Rights Commission, they were all again now appointed on the recommendation of the Constitutional Council. Professor Udagama referred to this. But unfortunately, there was this breakdown of relations between the President Sirisena and Prime Minister Ranil Wickremesinghe, which led to the latter's removal, Mr. Wickremesinghe's removal. He could not be removed, but he was purported to be, President purported to remove him. And he was made Mr. Rajapaksa the Prime Minister. He was expecting number of MPs to cross over and provide Mr. Rajapaksa with a majority in Parliament. That did not happen. And then he purported to dissolve Parliament. Now, this was not within that 4.5 years, but he purported to dissolve Parliament. But we were able to get it reversed in the Supreme Court because a challenge was now possible against a challenge was possible against actions of the president. They were challengeable, and therefore we were able to go to the Supreme Court, and the Supreme Court, in a historic judgment, unanimously 7-member bench of the Supreme Court declared the dissolution of Parliament unconstitutional, and Mr. Wickremesinghe was reappointed as Prime Minister. But all these gains were reversed in 2019 with the election of Mr. Gotabaya Rajapaksa as President, the current President, and Mr. Mahinda Rajapaksa, the former President, became the Prime Minister. And at the the Parliament elections in 2020, there was a near 2/3 majority for them. Still, they could not get a 2/3 majority. But again, they were able to entice a few people. They needed, I think, 8 members of Parliament to cross over, which they managed to do. And ironically, 7 of them were from the small ethnic groups, which was very, very disappointing. And all the gains of the 19th Amendment were reversed, except the 2-term limit was introduced again. Was there. It was not touched. The power of dissolution was limited to 2.5 years. So for 2.5 years, the president cannot dissolve. and the right to information, which was a fundamental right. The 20th Amendment Bill proposed that the immunity be also restored. But thankfully, the Supreme Court said that the restoration of presidential immunity would need approval at a referendum, and therefore the proposal was dropped. So we are back to executive dominance. And my own view is that the new political atmosphere, the new atmosphere created by the 20th Amendment is very inimical to the independence of the judiciary and also the independence of the other institutions, the various commissions I mentioned, the Office of the Attorney General, the Office of the Ombudsman, etc., which are all very so necessary, important for the rule of law. There have been threats to the media, veiled threats to media, environmental degradation. Every day you read about some forest being cleared by, somewhere. There's a lot of protests going on with impunity. Only yesterday we saw, I think that video is going viral. A driver had driven into a vehicle in which, and as a result, a senior police officer, rather not senior, so senior, but an officer in charge of a local police station was injured and he was hospitalized. And a traffic constable assaulted this driver in public, put him down, kicked him, jumped on him. Unfortunately for the country, some passerby recorded this and it's now going viral. Now, I don't think the police officer knew that it was being recorded. Now, so only because it was recorded that the government, that the country became aware of that. But there are so many such incidents. I'm not saying that such incidents never happened under the previous government. I'm not saying that. But now there is sense of impunity. And officials, both of the police and also administration, not concerned about the rule of law. The smaller communities, the numerically smaller communities have come under severe pressure. You may have read about it. We saw how burials were banned during the COVID, victims of COVID. Burials were banned and everybody had to be cremated. And of course now, thankfully, it has been taken off. And civil society groups are under pressure and quite under the scanner. I want to end my presentation with this Presidential Commission fiasco. A Presidential Commission was appointed by the President to report on political victimization of public officials of the police and members of the armed forces. It was chaired by a former Supreme Court judge, whom Deepika mentioned. And in the report, the three-member commission report, in their report, now they were to go into political victimization of public officials, but they went much further than that. And they now recommended that a number of government politicians and supporters of the government be acquitted from ongoing cases. I don't know how they are going to do it, but that is the recommendation. Probably prosecution authorities will come under pressure as a result because the government has in principle accepted the recommendations of the Presidential Commission. Now the really bad case is a case of a former member of parliament, a supporter of the government, who was convicted for multiple murder, found guilty by a trial at bar, 3 judges of the High Court, and his conviction was upheld by a 5-member bench of the Supreme Court headed by the then Chief Justice. Now, one of the recommendations of the Presidential Commission is that he be acquitted. How it is going to be done, I don't know. Whether maybe through a pardon. But here is a case. Here is a case where case of multiple murder, political murder, conviction upheld by a 5-member special bench of the Supreme Court. And now not stopping at that, the Presidential Commission has recommended that members of an anti-corruption committee, which was appointed by the Cabinet of Ministers, chaired by the President, and who went into some of these issues, handled the issue of anti-corruption, that a special presidential commission be appointed to see whether they could recommend civic disabilities be imposed on members of the anti-corruption committee. And that anti-corruption committee was headed by the Prime Minister, leader of the opposition, a number of political leaders who are now in the opposition. And there is this now, the possibility that civic disabilities could be imposed under this draconian law called the Special Presidential Commission of Inquiry Act. It was under that law that Madam Sirimao Bandaranaike, the world's first woman prime minister's civic rights were taken away for 7 years. So we are in a situation where there is a real serious situation of very serious, where you have serious threats to the rule of law. And I'm very happy that the international legal community has taken this issue up. I hope that your concern will help Sri Lanka to at least regain some of these things that we are losing. For the moment, I think that would be my presentation for the moment. Thank you very much.
Thank you, Dr. Jayambari. Can you, you're sharing screen still? Maybe you can stop sharing screen. Yes, thank you. Well, we've heard and read about this presidential commission and what it is recommended. And now you've told us in much detail. And I think many of us here listening to you, we are still a bit in shock as how this can be allowed to happen. Because it simply means the entire system of justice, the administration of justice, is turned on its head, and how the judiciary is going to function, because it makes it meaningless that there is proper adjudication, and those adjudication then is just nullified by the stroke of the pen, effectively. And if that is not a case where the country that has moved from a rule of law base to a rule by law base, then I don't know what is. Well, that's just my initial reactions. I'm sure there'll be questions from the floor, and I want to just encourage the participants who are here, and thank you again for taking time to log in and participate in this very interesting discussion. I think in the two presentations we have seen, we've actually got possibly the A to Z of what is Sri Lanka today and where it is today, and it is rather depressing. But I'm sure you'll have a lot of questions. And if you have your questions, please put them in the chat group, and we will take your questions. But now I want to move to the commentators. And we've got two commentators from within the South Asia region itself. And we've asked them to not so much look in or comment on the actual happenings in Sri Lanka, but to draw parallels so that we can learn, and maybe we can take a leaf or two of information and education from them as to how these things can be dealt with and how they have been dealt with indeed in their countries. So can I first take Mr. Hamid Khan? Mr. Hamid Khan is a senior advocate of the Supreme Court, Pakistan. He's a former distinguished council member of the CLA, a writer, a politician, and teacher. He's authored a number of books on Pakistan's constitutional law, comparative constitutional law, and he's a leading member of the Pakistan Bar. Hamid, to you.
Thank you. Thank you so much. I'm thankful to CLA for holding the webinar today, and particularly the subject on which we have heard the two speakers speak about the situation that has come to exist in Sri Lanka at present. However, my initial comment would be that the fears expressed by the two speakers are something that we have been experiencing for a long time. I think their fears are that they may not end up where we are in Pakistan. So therefore, in many respects, they will find things are very similar that we have it here, and they are still moving in the direction which we have already there. So therefore, I can see the fears that they have already expressed. We are going through that. So there are three things that I will confine myself to in regard to our experience. One is having a parliament, but meddling in the parliamentary affairs. Two is how the executive is governing at the present moment, though they enjoy much greater powers, but actually, are they in control of us? Three, how is the judiciary in these circumstances playing its part? Is it independent enough to be able to stop the excesses, or is it has shown itself to be helpless in the face of some very difficult circumstances? The first thing is that the parliament, elected parliament maybe, but does not have the power to really legislate the way it should be doing it. Most of the legislation, very important legislation in Pakistan, is taking place through presidential ordinances. What they do is bring a presidential ordinance, which can be valid for 4 months, can be extended one more time for another 4 months.
I think we have lost connection with Mr. Hassan. Hassan is, Hamid seems to have dropped off. Is he with you, Hassan? No, you are muted. We seem to have lost Hamid. What we will do is we will move on to the next commentator and then come back to Hamid when he logs on again. Can you hear me? Can the rest of you hear me? Yeah, okay, all right. Let's move on to our second commentator. And our second commentator is from India, and he's Mr. Herman Batra. Herman Batra is a well-known constitutional, corporate, and commercial and public policy lawyer with about 30 years of experience. And back with that extensive legal experience, he joined the profession, of course, in 1991. And after 3 decades, in 2019, he chose to join the independent counsel practice, and he specializes in diverse matters and appears, I see, in almost all courts in India, and certainly in the Supreme Court of India. He was elected as the vice president of SARC Law, and you would know what SARC Law is. It's the South Asian Association for Regional Cooperation in Law. It is a regional apex body established in 1990, and he's the longest serving Secretary General of SARC Law. Hemant was awarded the prestigious Mahatma Gandhi Seva Medal by the Gandhi Global Foundation for effective connectivity or connection between the legal communities of the SAARC region. And he's a distinguished writer and he's authored a number of books. Hemant, can we hear your comments now?
Yeah, thank you, Stephen. And good evening to all the distinguished guests and participants. As time is short, so firstly, at the threshold, let me add a caveat that I'll be commenting here as a lawyer and public policy expert from India and not as a spokesperson of SAARC law. My views and comments shall be based on the India case study, as Stephen had also mentioned earlier, that commentators would be speaking about their respective nations. Primarily, about the positioning of our judiciary, especially the highest court, the Supreme Court, the apex court, what view it has taken in respect of the rule of law. After having gone through a brief background note on the theme of this webinar and listening to the two eminent speakers, I'm of the view that there are about, three main issues or moot points which need to be addressed. Actually, there are four, but to begin with three, if there is time, I'll touch upon fourth as well. First, what could be the extent, scope, and role of the executive or the government in the administration of criminal law? Two, can a legislation or an executive order overrule a judicial order or verdict? Or let's say, can it intervene with the finality of the judicial order? Third, can criminal cases be tried by the quasi-judicial bodies or special courts or commissions? As I said, time is short. I'll deal with these questions or issues randomly and swiftly from the Indian rule of law perspective. Our code of criminal procedure empowers the government acting through public prosecutors to withdraw a prosecution with the consent of the trial court at any time before the judgment in the case is pronounced. It is an executive function of the public prosecutor for which, statutory discretion is vested in him. However, the discretion is neither absolute nor is it unreviewable. It is subject to judicial review like any other discretionary function. And it is vital that the grounds on which withdrawal from prosecution is applied should not be prompted by political considerations, motivations, personal vendetta, or completely irrelevant factors. Ordinarily, the government can apply for withdrawal of cases only on the basis of certain legitimate grounds, which are germane or relevant to the public justice. In several cases, in India, the courts have quashed discretionary action, taken by an authority on the ground that there existed no material on record for taking the action in question. Having said that, the courts in India have also held that the state is the master of the litigation in criminal cases. Yes, they have held so. But obviously there are conditions attached to that role. Further, the courts in India have in some cases struck down laws, creating special courts, commissions, tribunals to deal with problems of law and order, on the ground that these special courts were to follow a procedure less advantageous, mind it, less advantageous to the accused, in defending himself than the normal criminal procedure followed by the ordinary, criminal courts. Now, let me quickly take up the most important aspect. That is, can a legislation or an executive order overrule a judicial order or verdict? or can it intervene with the finality of a judicial order? Well, legislative overruling is the act of the legislature, which is very well recognized under the Indian Constitution. You may read Article 368. There have been instances in India where the legislature has carried out amendments in the statutes, in essence, nullifying and invalidating, mind it, the effect of judgments of the Supreme Court. Yes, the constitutional validity of these amendments also got challenged, and they were met with mixed response from the court. For instance, in one of the cases, titled People's Union of Civil Liberties versus Union of India, I'm forgetting the citation though, the Supreme Court settled the principle of constitutional jurisprudence that the only way to render a judicial decision ineffective is to enact a valid law by way of amendment or otherwise fundamentally altering the basis of the judgment, either prospectively or retrospectively. So the legislature cannot overrule or supersede a judgment of the court. It cannot, without lawfully removing the defect or infirmity pointed out by the court, because it is obvious that the legislature cannot encroach, trench on the judicial powers vested in the courts. Now, having said that, the trend of passing amendments to nullify judgments of Supreme Court has continued, and some have been upheld as they passed the test of reasonability, because they never took away the guaranteed fundamental rights and were not held to be violative of the basic structure of the Constitution. So these two tests were passed. So they could very well overrule the judicial verdicts then. But insofar as executive actions are concerned, undoing judicial verdicts by executive actions have never been tolerated at all, not at all. Now, quickly addressing another moot point of a tribunal or a quasi-judicial body versus a normal criminal court. There are several arguments against empowering tribunals, etc., with criminal jurisdiction, as it is felt that these are arms of the government, and hence they could very well be biased and would be less impartial and independent. But the Indian rule of law regime, Stephen, holds them good because Article 323B of the Indian Constitution enables the legislature to make law providing for the adjudication or trial by tribunals of any disputes, complaints, or offenses with respect to the specified matters. The matters are specified in that article. So quickly, I may now close my comments as time is short by pointing out, another fundamental power of the executive, as Jampati was also mentioning about the power of pardon. The President of India and the governors of the states in India have constitutional power. Under the Indian Constitution, obviously, to grant pardons, acquittals, exonerations, respites, remissions of punishment, or even suspending, remitting, or commuting these sentences of convicts. This is constitutional power. Though I must remind and emphasize, they are rarely exercised. They are rarely exercised. The Supreme Court has ruled that it is befitting to grant another degree of protection in the matter of life and personal liberty, and it is open to the president and the governor, as the case may be, to scrutinize the evidence on record of a criminal case and come to a different conclusion from that recorded by the court. And the power is not judicial power, but is a constitutional power. Though Supreme Court has upheld these kind of constitutional powers, however, that has not in any which way given free hand to the executive to exercise such powers of pardon. They have been very, very rarely and in exceptional cases exercised, and not sweepingly. I think I'm good to go.
No, that was very good, Herman. Thank you very much. I think you touched so many key points that I think would be the source of, I think, questions that can be placed after this. And we'll come back to that. Thank you very, very much. I just want to go back to Hamid. Hamid is back online. Hamid, can you just wrap up your comments in about 3 minutes or so, and then we can take on some questions. You are muted at the moment. Can you unmute? Still muted? Yes. Okay.
Okay. I was just giving a recent development in which chairman election of the Senate were disputed and the courts did not interfere. And ultimately, an understanding was reached by which the person who lost the election for chairman was ultimately accommodated by the same chairman as being notified as the leader of the opposition. And that was where they settled the matter. Other parties of the opposition feel that this deal was not the right thing to have been done. So what I'm trying to say with this very recent incident is that there was a manipulation in the voting. That was a parliamentary practice, was interfered with. And the declaration of the result was not correct. Then the judiciary failed to interfere and correct over there. And ultimately, the matter was settled outside the parliament in a way by which some satisfaction was given to the party which apparently lost, ostensibly lost, but was actually aggrieved. So what I'm saying here is that after hearing the address of both the learned speakers, it appears that Sri Lanka is on the path on which we are much further ahead. And I strongly feel that's right time to prevent any further moving on to that, on that direction. The sooner that is done, the better. It's good that they've raised this question. They have brought out their fears and apprehensions that they are feeling from the developments that are taking place over there. We have much richer experience of that happening over here, where there are strong expressions of dictating the steps in this behalf, and therefore the fears that they have, we hope that are not materialized, and something can be done before situation reaches where in many situations we have already experienced. So thank you so much. This is what I had to comment on this situation.
Thank you very much, Hamid, for your, again, very succinct comments and for pointing out the problems that you have in Pakistan. And I think we can learn from particularly the steps that you have taken, leading the bar and standing up to this, what would be anti-rule of law measures within your country. We want to take on some questions. I've not got any questions in the chat group, but something came to mind listening to both our commentators really, and I think the concern is, and if you have a thread that runs through the entire situation in Sri Lanka now, there are a lot of measures which only can be best described as extrajudicial. So where the judiciary is, I think, effectively being bypassed, in that sense, the administration of justice is being bypassed. I wonder whether either Dr. Jayambati or Dr. Deepika can shed some light into your presidential power of pardon. Now, is that size of that power open to judicial review?
Yes, because when the 19th Amendment was passed, or rather the immunity was taken away, there was only one saving, that only the declaration of war or peace would be immune from judicial scrutiny. So that was made very clear. And already there is a case pending. The former president, Maithripala Sirisena, who pardoned, that was a death penalty case. Of course, Sri Lanka, death penalty is only on paper, it has not been carried out. But that apart, a pardon has been challenged. Of course, the case is not over. So the Supreme Court last time also, and in the dissolution case, made it very clear that apart from a declaration of war and peace or of peace, any official action of the president can be challenged under the fundamental rights jurisdiction.
Okay, so the right to judicial review is still there, and that is, I think, a saving grace.
Yep.
But of course, for that right to be exercised and for you to get the right result, the institution is important. The judiciary is very important. So maybe I'll ask Dr. Deepika. Now, you spoke, when you spoke just now, you quite rightly pointed out to the fact that institutions of state are critical. And it's at times like this, when the rule of law is under stress, the institutions of state have to stand independent. And you can talk about, you've got your bribery commission, which is a constitutional commission, and you may have other constitutional bodies who all have to live up to what they are at this point of time and not built under political power or pressure. Do you see the judiciary in Sri Lanka standing up to, I think, what is a very difficult situation when it's so obvious that the politicians have an agenda, they have certainly a campaign, a game plan, and that's what they want. And the only thing that's standing between them and achieving the result is, I think, a robust, independent judiciary. Do you see that? Is that something that Sri Lankans can look to? And if not, and we can understand that it's not easy, perhaps what the international community, those who are here, and the CLA can do to support and stand with the institutions and particularly the judiciary in this difficult time?
Well, that's a very good question. I think lots of new members of the High Judiciary have been appointed by the new president under the. So they have not been vetted by a collective body like the Constitutional Council. It's left to be seen how some of these, important cases will be adjudicated by the superior courts. I mean, there have been from time to time in the past few months a few good fundamental rights judgments in cases that are not controversial. But the real test is about, what we call these emblematic cases. So, for example, about the Commission of Inquiry recommending letting these persons go free, what would be the reaction of the judiciary? Because eventually it is the call of the judiciary. The cases are pending before the judiciary. So even if the Attorney General wishes to withdraw the indictments, prosecutions, it will be interesting to see how the judiciary reacts. So it's a little early, really early to say. We were watching to see how the judiciary would respond to the challenges brought to the draft 20th Amendment bill. Many of us expected to see a wholesale approval in a way. I mean, I don't know, many people, I mean, there were different viewpoints, but those who thought that the judiciary would, be careful, would completely agree with all the provisions. That didn't happen. It was a sort of a judgment with mixed results. But from the point of view of civil liberties champions, the judgment didn't go far enough. So, for example, about the appointments of commissioners to independent commissions, in my opinion, with due respect to the court, I think the judgment glossed over it and, didn't really make a point that protection of rights requires independent commissions. And so appointment of the commissioners themselves are as, important. That was glossed over. And so therefore we have the current arrangement under the 20th Amendment where the president can directly appoint, all the commissioners and all the judges and so on. So it's left to be seen, especially with the new appointments. So that's what I have to say.
Thank you, Deepika. Now, Hamid, we know that you led the famous lawyers' movement against the military dictators in Pakistan in 2007. And, you know, in this, when you stand up for the rule of law, on the one side, you, of course, need the independent judiciary, but it's equally important that you have an independent bar. And the lawyers stand up both individually as well as an institution when the rule of law is under challenge. Is there something that you would advise the lawyers in Sri Lanka, the Bar Association in Sri Lanka, as to what is their role at this difficult time? I know, having been a bar president in Malaysia, and I'm coming under tremendous pressure by the politicians, this is not the time for you to back down. This is the time to be, if you like, eyeball to eyeball with the dictator. That's the approach that I took. What would you say, Hamid? Yeah, you're muted, Hamid. Can you unmute, please? Still muted, Hamid.
Unmute.
Unmute, Hamid.
Unmute.
Unmute, Hamid. Yes. Still muted. Oh dear.
Can you not do it, Steve, yourself?
I will try. Rahul, can you try, Rahul, to unmute him?
I think he's not listening.
Yes.
Now can you hear me?
Yes, loud and clear.
You see, our experience has been that if the bar stands united and behind the judiciary, then the judiciary is likely to be independent. And that's what our experience has been. But of the last about 8 to 10 years after we had a successful lawyers movement, we found that those who do not want to see an independent bar and independent judiciary are working against it to divide lawyers amongst themselves and also to divide judiciary as far as possible. The ideal situation is always there where the bar is united, strong and independent. And by all means, the judiciary is likely to be strong and independent. If that can be achieved, I think this is a situation where they should stand together for a strong and independent judiciary.
Thank you very much, Hamid. Hemant, one question for you. Now, ultimately, it is of course an internal problem in Sri Lanka, but we are here today for a particular purpose. Whatever it is, insofar as we lawyers are concerned, and most of us here, I think, are lawyers, there is a sense of solidarity when we talk about the rule of law. We may have different interpretations of the rule of law, but on the most basic level, we all have a common understanding of what the rule of law is. And when the rule of law is violated in one country, we always look at it as being violated everywhere. In other words, if we do not speak up against it, then it may fester and others may take encouragement from it. And indeed, you may see it then spill to other countries. Now, and you are a person who has an international perspective. What can we do as an international community to stand in solidarity with Sri Lanka?
Well, I would say that, insofar as looking at it from the perspective of bar leadership, that I think I will leave it up to Priya, because Priya is one of the leaders of the Indian bar as a whole. I mean, she's a national leader. I would sort of request Priya to touch upon that part during her closing remark. Now, with regard to how we can amplify the grievances and the issues which are there are obviously two ways. One is fighting it out within the four corners of law, that is by leaning on the processes of rule of law, judicial review, and so on and so forth, because whenever there is change in the governance at the executive level, one does face such kind of issues, and you have to challenge them in the courts of law, and strong courts and strong judges do give you relief. And in India, we have seen that judges have been very, very strong in coming to the rescue insofar as human rights is concerned. And we have system of separation of powers, but that separation of powers is not that everybody enjoys a watertight authority. There is a system of checks and balances as well. So all three organs of the government enjoy sufficient independence, but at the same time, they also are subjected to principles of accountability. Now, that is one way of looking at it. Second is obviously through the means of pressure groups, what you are referring to primarily. Now, there, what one could do is that, if the discussion is not becoming political in complexion and nature, then I think any forum like Commonwealth and similar other forums of lawyers association can take up these issues and discuss in a civilized manner, in a civic manner, as we have discussed today. And that will create, a segment of pressure groups, which could sort of lead to, some resolution, which will be beneficial to the larger community of the Sri Lankan, of the nation.
Thank you, Herman. And I think you've actually hit the nail on the head, because speaking for the CLA, I think the conversation on Sri Lanka has just begun. And it is not today, and it's not going to be over. I think we want to continue to stand with Sri Lanka. We want to be supportive in the way that you have quite rightly mentioned. We are not interested in the politics. We are interested in the rule of law. We are lawyers. We're interested in the rule of law. We are interested in good governance. And we want to see that practice across the Commonwealth, indeed in all countries. And so we speak up for that. So I can tell you for sure, the audience who are here today, this is just the first installment insofar as the CLA is concerned. We will be coming back again with another webinar and other things that we will do to stand with our colleagues in Sri Lanka as they go through this difficult time. And we all reminded that we all at different times go through this in the history of our nations. And we have stood up for others, and they have stood with us. And it's time for us to be counted with them. So insofar as Sri Lanka is concerned, and the participants from Sri Lanka are here, please rest assured that you will always have our support, and we are not going to fall back exhausted after having one webinar. Now, with this, I want to now, we have run out of time, and it's unfortunate. I'm sure there are so many questions that we can get to, and we will certainly get to it possibly the next webinar that we have. I'm going to invite our closing speaker for this evening in Malaysia and other times of the day throughout the world, Ms. Priya Hingorani, a senior advocate of the Supreme Court of India. She's been in active practice since 1990, very active in human rights work, and has handled public interest litigation and constitutional law matters in the Supreme Court of India and the Delhi High Court. Along with her private practice, she was empaneled with the Union of India Panel A for arguing matters in the Supreme Court of India. Currently Secretary General of SARC Law India Chapter, and a former Vice President of the Supreme Court Bar Association, New Delhi. To you, Priya. You're muted, Priya. Rahul, I don't know whether you can unmute. Okay, you're unmuted now.
Okay,
Yes.
thank you. Thank you very much. Can you hear me?
Yes, we can.
Yeah, okay. Thank you very much. A very good evening. It has been fascinating to hear the speakers from Sri Lanka, Deepika ji and Jayapati, and the commentators who have given their perspectives. I would like to add a few of my perspective to this before I formally close the webinar. Taking off from what Hemant said about how should the bar react to this, and I really strongly feel that the bar has to be very, very strong. We have had instances in the past, where it is because of the strength of the bar leaders and the bar being united that we have been able to assist the courts in taking decisions and have supported the judiciary. As we all know, the judiciary speaks through its judgments. But if they are in pain or there are issues which the judiciary is not able to speak out about, it is the bar which speaks on behalf of the judiciary. So having said that, we've had instances where we have felt somewhere the bar has failed as well. But by and large, I feel in India, whether it is at the district court level or the high court level across the country, the bar has taken very firm stands on very issues related to human rights and the rule of law. We have stood by the judiciary. The issue which I feel is very important, which needs to be addressed, is which we are still struggling with in India, is on the appointment of judges and the quality of judges and the procedure and the manner of appointment of judges. By and large, we've done fairly well. We have got excellent judgments which speak of the quality of the judges. But at the same time, we do at times have aberrations, and we feel that we need to reconsider or look at the way the judges are appointed. I think Sri Lanka particularly is at the moment facing a different kind of a situation. And as Deepika said, that though some judges, new judges have been appointed, they are yet to see how they would be reacting or giving out judgments on issues which would be controversial and which may not suit the government of the day. So it is for all of us to see. In India particularly, I find that the civil society takes a very strong role in taking up issues concerning human rights and the rule of law. While we have the institution, the new jurisprudence, well, not so new, but of public interest litigation in India, which has led the way in bringing out cases before the courts, a lot of civil society has taken it up, whether it is journalists, for Indian service officers, lawyers, just election commissioners, who have taken up issues which have concerned the society at large, which have violated the human rights, which has questioned the rule of law. Though they have, in their own capacities, come before the court, filed petitions, and there have been judgments which have kind of upturned the legislative decisions, which is, I think, something which I feel in Sri Lanka, and I'm read about it, that a lot of members are from the civil society wanting to come forward and raise the issues, but it's just that they are not covered by the media and they are not getting this actual support that they should be getting. Recently, as we all know, that the International Bar Association, Human Rights Institute, as well as the Bar Human Rights Committee of the England and Wales passed a resolution on the 5th of March 2021, supporting the stand and asking for accountability to be for human rights violations and the adequacies of domestic mechanism. And they have come out very strongly, and the statement was circulated and shared with, and I think the Commonwealth Lawyers Association has also endorsed it and stated that we are standing in support with the Sri Lankan legal community and the people of Sri Lanka. Having said that, I would like to thank all our speakers who have shared their views. But personally, I would like to thank Mr. Santhanam Krishnan, Mr. Upal Jayasuriya, and Stephen Theru for working over the past few weeks to put this webinar together, to make sure that it went through with great speakers, with a great insight into what the issues are, and our commentators who have shared their thoughts from their country's perspective. And also thank you to all the members of the bar and the civil society who have joined this program, who are viewing this program. And we hope to be back again, as Stephen said. We hope to be there with you in another series of webinars and to take this forward. This is not the end of it today. Thank you very much.
Thank you very much, Priya. And before I close the session, I just would like to announce that, there is another webinar tomorrow by the CLA. It is military justice for our soldiers, and look at different military justice systems. That is at 10 a.m. British Standard Time and 2:30 p.m. India Standard Time. Do try and log in for that. And we will see you again at the second installment of this webinar on Sri Lanka, not too late in the future, if you may, sometime probably in May or June, and where we will assess what has happened in Sri Lanka and take up these issues again. Thank you again very much for all the participants.